Good afternoon and welcome to the District of Columbia Court of Appeals. We have one case on the calendar this afternoon. It is 23 CM 991, DWAYNE T. Hawkins versus the United States.
Good afternoon, Your Honors, and may it please the court. Adrian Madsen on behalf of Appellant DWAYNE Hawkins. I'd like to reserve 3 minutes for rebuttal. In recent decades, courts from the Supreme Court to this court have engaged in far closer scrutiny of plea agreements, expanding judicial review of the plea bargaining process in areas such as the right to the effective assistance of counsel, from Lafler versus Cooper to Missouri versus Fry, and more. And courts have done that for very good reason. As the court stated in Lafler, the criminal justice system today is for the most part a system of pleas, not a system of trials. 97% of federal convictions and 94% of state convictions are the result of guilty pleas. While it has long been established, going back to Santo Bayo, that plea agreements are interpreted as contracts, with the government held to a strict standard of compliance, and with courts, including this court, reviewing plea agreements to determine whether a breach has occurred. The United States, in this case, and many others like it, seeks to usurp the important role of judicial review, instead assume the vital role of the judicial branch. The United States' efforts to displace the role of trial court should concern this court. As mentioned in Mr. Hawkins' motion for oral argument, deferred sentencing agreements, which is what ultimately brings us here today, are the only type of diversion offered in misdemeanor domestic violence cases. The consequences of conviction, i.e. in the event that a deferred sentencing agreement is revoked, can, including for the offense at issue in this case, carry a lifetime ban on possession or use of firearms. In other words, they are serious. The offending illusory provision at issue in this case is remarkably broad in scope. It is not simply a provision purporting to invest in the government the discretion to determine compliance with one condition of a plea agreement, but compliance with any part of the agreement.
But counsel, I can see your argument, I suppose, if the notion is just that the government can walk in and say, we decide to revoke and we're doing so in good faith. And that's the end of the story. But regardless of how the trial court sort of characterized some things, is it not true that one specific provision of the DSA required your client to show up at the review hearing with proof of attendance, and that was not satisfied, and that itself was a breach of the DSA by your client?
So the provision in question reads, just to make sure you get the language exactly correct, the defendant agrees to provide written proof of attendance on the scheduled review dates. The sentence that follows that is that the defendant agreed to provide written proof of completion of the indicated programs on the scheduled sentencing date. So it is true, there is a provision that provides that the defendant is to provide written proof of attendance. However, read together, where the requirement is that the program in question here, the domestic violence intervention program, be completed within the 9-month period. Without having sort of any specific number tied to that, it's unclear why that would itself be a breach.
I mean, along those lines, sorry, go ahead.
I'm not sure I understand why it would be unclear. I mean, your client pleads guilty in April, and they, pursuant to the deferred sentencing agreement, their review dates, right? That target dates. And so the review date is set, the initial review date is set for July. What do you think was supposed to happen in July?
Sure. So a few things. I mean, one, there were certainly other provisions of the agreement that were at issue.
But we're just focused right now because Judge Schenker directed our attention there on the review date. So I'm trying to understand what you think the purpose of the review date was.
Yes, and that's what I was endeavoring to answer, Your Honor. That is that to make sure that Mr. Hawkins had, certainly that he had not violated any condition of the agreement requiring him from from doing something. In other words, this provision was not the only purpose of the review hearing. That is, there were a number of other.
That compliance with the DVIP program was one purpose of the review date, or do you think that's far from obvious?
So I think that is not obvious. What I mean is that the end requirement here is that Mr.
Wasn't,
Hawkins.
I'm sorry, what was the language again? Did you read that you were supposed to produce written proof of attendance at the review date? So why is it not obvious?
Because reading the other provisions together, where the only the end requirement here is that he complete this program within the 9-month period of the deferred sentencing agreement.
Well, if we
And there
read
was-
the other provisions together, we see that your client had to register within 72 hours of the plea agreement to get started on this. And there's other points that, like the two provisions that have been mentioned already, seem to indicate that the agreement wanted your client to get moving fast and to be going kind of throughout this. And so why isn't that the better reading of the contractual agreement?
For one, again, I just want to make sure that it's clear that the time between the review date and the end of the agreement, that there were more weeks left within that 9-month period than sessions required of the domestic violence.
Yeah, but why
intervention.
can't it be true that the agreement contemplated your client not just both complete it within 9 months and to have attendance at periodic times throughout the 9 months? I mean, those aren't inconsistent with each other,
Sure, I guess a couple.
nor are they redundant. I mean, they are separate, right?
A couple of points on that issue. That one, as the court may have seen in the hearing at which the review date was being set, the trial court didn't say it has to be exactly this amount of time when the review date is being set. So this was, I mean, I guess this is outside the record here, but I've certainly seen cases in which they're set much shorter, they're set much longer. In other words, it is not tied to a specific period, and the trial court didn't, rigidly insist, okay, it's going to be at this period because we know that at this period, Mr. Hawkins should have completed this number of sessions. And so it is.
Well, perhaps not. I mean, because there's some flexibility. Who knows what the demand is for the programs? And so, you don't know what CSOS's capacity is. But certainly the record reflects that the court was quite surprised when they showed up in July after your client pled guilty in April. And the court learned from CSOSA that your client had attended no sessions of the program.
I agree.
So
that
it would seem to indicate that there was some expectation that there would be at least documentation of attendance once.
I agree that the record reflects the trial court surprise, and I agree that appeared to be the trial court's impression. I think that is a different issue than is for this court in terms of interpreting what I'm not sure that the trial court's impression of that carries any particular weight where this court is reviewing de novo the terms of the agreement.
Would you say if there were a review hearing on the 8th month and 30th day of the 9-month period, and your client had not taken a single class, it seems like your position would require you to maintain your anticipatory repudiation position even at that point?
No, I disagree, Your Honor. That is, I think through there are either through words or conduct, anticipatory repudiation reflecting a clear intention not to perform. At that stage, it would not be possible for someone to perform. That is, to complete the 22 weeks, even if we are assuming here that he is limited to 1 per week. I think that conduct would certainly convey a clear intent not to perform.
Would you agree that if he were limited to 1 per week, he wouldn't have been able to perform in this instance?
No, I disagree. That is, there were more than 22 weeks, which is the number of classes
On July
left.
25th.
Yes.
But assuming it took even a week or two to get into the program and that there's a set schedule and this isn't some specially ordered, catered to your client situation, I mean, how much time would he have really had?
So I think there is there's an absence of evidence in the record, regarding those issues. But there were, by my count, approximately, if I recall correctly, about 24 weeks remaining between the review date and the end date. And that's again, assuming which there was not a representation from CSOSA. So we do have the trial court statement, but there wasn't a representation from CSOSA that, for example, he would not have been able to complete more than 1 class per week. And so, and I do want to note here that what the trial court ultimately did was not itself find, and I think from the government's brief, the government agrees with this reading, it was not to find that Mr. Hawkins had in fact violated the agreement, but that the government could have found without acting in bad faith that Mr. Hawkins violated the agreement, which brings us back to what I submit is this illusory provision of the agreement. That is, the government points in its brief and also cited in Mr. Hawkins' brief to Jones, for example, and the facts of that case are meaningfully different in different important way. That is, where the government is evaluating something like whether somebody has provided substantial assistance, that's necessarily going to be something that is kind of peculiarly within the knowledge of the government. Here we have a provision that purports to give the government total control regarding any terms of the agreement and things that are not peculiarly within their knowledge, things that are readily ascertainable, just like they would be in the context of probation.
But it's not total control because there still is this good faith backstop, no?
Well, I want to note
things that I found kind of confusing about the brief was that both sides were saying the government has exclusive control. And I thought, well, they don't have exclusive control if the trial court has some sort of good faith check over it. So it was an odd point that both parties seemed to be in agreement on. And I thought this seems strange since clearly the court has a role to play.
Well, at least my read of the government's position below was that it had exclusive discretion, total discretion. That is that, regardless of good faith or bad faith,
The government might have showed up and just sort of expressed that, but the court played a part. Do you disagree? I mean,
so I agree that ultimately what the court did was to find that the government could have found that the agreement was violated without acting in bad faith, which is.
And the government says in its brief to this court that there is this good faith check on revocation. So even as it's saying we have exclusive control, it is acknowledging that there is this limitation.
And so as the DC Circuit pointed out in Jones, which is cited by both parties here, that's in terms of alleging bad faith, that is going to be incredibly difficult for the defense to do. The defense is not, I can get the exact quote from Jones here, but isn't going to be privy to the government's internal communications or deliberations about why they're making this decision. So it's
but on these facts and on this record, it's pretty obvious why the government, I mean, CSOSA comes in and says he hasn't showed up, he hasn't done orientation. And to your point about CSOSA not saying that he couldn't complete the training, I mean, maybe CSOSA didn't say that, but CSOSA said, we will be requesting that the DSA be revoked. They were asking for it, presumably because they thought that he couldn't complete the training.
Well, I candidly, Your Honor, I'm not sure that this isn't a case of probation for something where the trial court would normally seek the CSOSA's position. I'm not sure that their position on what the government should do about whether to seek revocation of the DSA or not should, one, carries any weight, and two, should be interpreted.
It's not that it carries any weight, it just sort of suggests that CSOSA thinks he's not going to get through our 22-week program.
Well, I mean, that is one potential reading of what the reason for CSOSA's statements. Another reading of that is that they thought Mr. Hawkins had not shown an interest in participating, and for that reason thought the deferred sentencing agreement was revoked. So I certainly don't think there's something clear that would, from CSOSA's representation, that would indicate, whatever the value of CSOSA's interpretation of both the agreement and the number of sessions. I certainly don't think it's clear that CSOSA was saying he couldn't complete it within a period of time.
There are qualitative provisions in these type of agreements and more yes or no provisions in these types of agreements. And I agree with you that this language about government deference or exclusive determination is born out of substantial assistance concepts, but, and probably, might have a poor fit for other provisions of an agreement. But here, the government did come forward in the trial court and say, your client violated the provision requiring him to show up with proof of attendance. And that's sort of a yes or no thing. I mean, I don't see a qualitative sort of determination by the government there. And I agree, could the trial court have said more on that? Perhaps. But still, if the answer to that is no, your client did not have that proof of attendance, then I'm not sure what role this exclusive determination term really has to play here.
Well, I think that the role that it did play below, right, was in what the trial court ultimately did, right? That is, the trial court didn't find that Mr. Hawkins had violated the agreement. The trial court found that the government could have found without acting in bad faith that Mr. Hawkins violated the agreement, which I think are pretty clearly different determinations.
I know, but I guess, whether you call it a harmless error analysis or what, or just ascribing it to some or, language decisions by the trial court, if at the end of the day, your client did not come forward with proof of attendance at the review hearing, and I know you disagree with this, but we consider that an express term of the contract, then where are we? Because that seems to be an affirmance.
So I would agree that if the court read that provision as an express term of the contract, and that the court, it's not disputed that Mr. Hawkins did not come with proof, that the court, under that reading of the contract, could affirm. I disagree with that reading, but I think under that reading of the contract that the court could affirm. I think that would take us to the second major issue in the brief here, which is the denial of the motion to withdraw the guilty plea. But in terms of on that issue, under that reading, I would agree. I see that my time has expired.
Do you want to address the withdrawal of the guilty plea?
Yes, I would.
Okay.
So the trial court abused its discretion in the absence of specific performance. The preferred remedy for Mr. Hawkins is seeking here. First, by failing to consider the lack of prejudice to the government when considering the length of the delay, which this court has indicated is the main or the principal fact to be considered when evaluating the import of the length of delay, one of the three gooding factors. The government proffered no specific prejudice below. The government has proffered no specific prejudice from the delay in this court. This was a 2023 case. It is certainly true that in absolute terms, the period of time between the plea and the seeking to withdraw it is longer than cases in which this court has affirmed, but these are factors, obviously not elements. And as this court reiterated in Edwards, again, prejudice to the government is the main purpose of this factor, and the trial court did not.
Well, it seemed to me that the trial court seemed to be looking at all the circumstances around it and determined, at least very strongly implied, that, well, I don't think you're really making an innocence claim. I think you're throwing a Hail Mary or something at this point after the fact. How should we view that in the calculus, or do you think it even has a place as we look at this under an abuse of discretion?
Sure. So what Mr. Hawkins proffered was pointing to evidence that was in body-worn camera footage from the case. That is, statements that Mr. Hawkins made regarding what had occurred prior to the police arriving, indicating that he may have acted in self-defense. And so I think the relevance here, Judge Howard, to answer your question, is that the trial court didn't engage in an assessment of whether he had put forward facts that, taken out as true, made out some cognizable defense to the charge, which is the second way that the trial court abused its discretion regarding this determination. That is, there is a difference between the trial court did a comparison, which is permitted, between what Mr. Hawkins stated at the time of the plea and what he was asserting in the motion. But there's certainly a difference between the government not being able to disprove self-defense beyond a reasonable doubt and a person agreeing that he or she acted without legal justification, even assuming an understanding that acting without legal justification includes the absence of self-defense. So I think that to answer your question more directly, Judge Howard, that the relevance of that is that the trial court failed to engage in the required assessment of whether he had put forward facts that made out a legally cognizable defense. And so by saying that, I think in your Honor's words, that this is some sort of Hail Mary, that the trial court failed to consider a relevant factor and abused its discretion in doing that. Thank you.
Thank you, counsel. I'll give you a few minutes in rebuttal.
Good afternoon. May it please the court, Mark Hobelt from the United States. I would like to begin, I apologize in advance for my voice. I would like to begin with the proof of attendance point that was raised here, because that would be dispositive if that's it. And that is a condition of the DSA. In other words, the court would not need to go further to find that the defendant breached and the government's revocation was appropriate. It was the shared understanding of all relevant parties here that after Mr. Hawkins entered his guilty plea to assault, that he was going to enroll in and attend the domestic violence intervention program, the DVIP classes. It was the understanding certainly of the government, and CISOSA is expressed at the July 25th review date hearing. It was also the court's understanding, as I think one of you noted, the court's reaction was was goodness gracious. She was stunned. Judge Knowles was a little surprised and stunned that Mr. Hawkins had not been attending. I note two other points in the record that I think go to this shared understanding among all parties. One is defense counsel's reaction after CISOSA on July 25th, after CISOSA had informed the court and the parties that Mr. Hawkins had never reported for DVIP orientation. Defense counsel said, and this is on page 3 of the July 25th transcript, as I think was alluded to by Ms. Boone, the CISOSA representative. So Mr. Hawkins both called and went to CISOSA in an effort to begin the DVF classes. I recognize that separate from that, he has an obligation to follow through on that. And then later in the same paragraph, defense counsel stated, this is not any sort of willful non-compliance. So there was I think an implicit recognition that there was Mr. Hawkins was not compliant.
So counsel, you didn't really rely on this very much in your brief here. And maybe that's because the trial court didn't rely on it. And that's what gives me some pause here. And so I think this would be a much easier case if the trial court had just said, agreement requires you to show up here today with proof of attendance. You don't have any, you breached, government can revoke. But trial court seemed to say two things. One, which is that you're not going to be able to complete this in the 9 months. And we don't know if that's true necessarily or not at this point. And number two, the government can revoke this agreement for any reason whatsoever, whenever it wants to, as long as it does so in good faith. And I'm not sure that's quite right either. So where does that put us?
Right. And I'm happy to address the revocation provision because I do think, and I think that's correct to say the trial court relied most heavily on the revocation provision and it was appropriate to do so and correct to do so. I think getting to some of the tension that maybe Judge Easterly pointed out in addressing the questions to Mr. Madsen about how does good faith fit into the exclusive determination language? The DSA's revocation provision does give, and we bargained for, the right to exclusively determine whether Mr. Hawkins was complying with his DSA conditions. And if he were not to do so, we had the right to revoke the DSA and move straight to sentencing. That being said, every contract carries an implied covenant of good faith and fair dealing. That is consistent with the Jones case from the DC Circuit, which was a substantial assistance plea agreement case. This contract does too. And so when
but does that mean if you got it wrong, that the party on the other side, the defendant, violated provision in the agreement, you got it wrong, but you got it wrong in good faith? That you can revoke the agreement?
Right. So I think that's where this cashes out. Let me explain. So the defendant, in alleging a breach by the government and alleging he's entitled to specific performance, he can't rely on, he's acknowledging that under the specific terms of the contract, the government is entitled to revoke if it determines there's been a violation. But he is alleging a breach of the implied covenant of good faith and fair dealing. That is to say that if we do not exercise our rights under the contract in good faith, if we do it in bad faith, we do it arbitrarily and capriciously, and that's how this court has defined the implied covenant of good faith and fair dealing, then we are in breach. Here, the trial court explicitly determined that the government had exercised its rights under this contract in good faith. And there has been no challenge to that specific, we would call it a factual determination. The government, the trial court's factual determination.
Right, but I guess I'm asking you if that good faith, implied good faith requirement means that any party to any contract can come in and say, other side violated term X of the contract. We think so in good faith. And turns out party never violated it, delivered whatever it was supposed to deliver on that date, but the court has no obligation to look into that simply because you in good faith thought that the party violated that term. I mean, that can't be the way we read contracts, is it?
I'm sorry if I'm misunderstanding your question, Judge Shanker, but I think that when we determine that there has been a breach and we determine that there was a violation by Mr. Hawkins with respect to the proof of attendance provision, with respect to the abiding by CSOS's directives to attend DVIP classes, really to attend DVIP classes in a timely way, which is a critical condition from our perspective of this contract, of this plea agreement. At that point, when we're revoking, the trial court can ascertain, and trial courts engage in this sort of assessment. I think some of the substantial assistant cases go into this, engage in this assessment of good faith. Is a party complying in good faith with its obligations under the contract? But that's separate from the reason we're at that stage is because the specific terms of the contract give the government this exclusive right to determine whether Mr. Hawkins has violated it. So that's where I think this cashes out. And I hope I answered your question. If I did not, I apologize. But in this case, at best, Mr. Hawkins can say the government can allege the government breached its implied covenant of good faith and fair dealing. He'd have to demonstrate bad faith. He did not do so. He has not challenged the trial court's determination that we did not act in bad faith. We act in good faith here. So that I think it is.
So you think there's no role of the trial court to independently determine whether Mr. Hawkins violated any specific provision of the contract?
I think that question could potentially feed into an assessment of whether we acted in good faith, but as an independent matter, no. I mean, I do want to maybe just take a step back and give a little more context on the deferred sentencing agreement, because I think this in part goes to your question, Judge Shanker. From our perspective, what we are trying to accomplish with the deferred sentencing agreement, we have defendants with minimal criminal history, especially in the domestic violence context. We really want them to go to domestic violence intervention program classes because we want to address the root causes of the DV problem here. And the carrot in a DSA is that if they do that and they take those classes and they comply with the other provisions, we will dismiss the entire case against them. And the stick is that if they do not do that, we, the government, are in a position to determine whether or not they violated the DSA. And if that's the case, we revoke and go to sentencing. That's the stick. And that first order determination does not go to a court. This is the specific bargain that the parties struck here. So from our perspective, we get the benefit of our bargain. He gets the benefit of his bargain. And in this case, he just, the shared understanding of everybody involved was that he was going to attend DVIP orientation. One other point in the record that I'd wanted to pull up before that we didn't highlight in our briefs, during his actual guilty plea on April 4th, at page 6 of the plea transcript, he was actually asked by the court during the colloquy,
you're required to enroll in the domestic violence intervention program that CSOSA will get you hooked up in those classes. Do you understand that? And Mr. Hawkins said, yes, ma'am. That's to enroll in. So it was a shared understanding he was going to go to classes. I'm happy to address the plea withdrawal point. I'd say I direct the court, and especially in response to the defendant's points here, I did direct the court to the Bennett case, which I believe which we cite in our brief, and especially that in dealing with a claim of innocence, the trial court, it does not abuse its discretion by determining, by assessing whether the defendant has offered evidence in support of the innocence claim and a convincing explanation for his failure to assert that claim at the time. That's 726A second at 169, the Bennett case. And that's what the court did here. The court looked at the whole context and the fact that this was the withdrawal request was really an alternative request after the motion for specific performance had failed.
Paul for Mr. Hawkins stresses that the delay factor is really a prejudice to the government factor, and says the court didn't assess prejudice to the government.
Right.
What's your response to that?
Yeah, I direct the court to the same Bennett case. I think we cited this in our briefs that the government does not have to demonstrate prejudice for a lengthy delay of months to weigh against the defendant in the context of a plea withdrawal motion. So with that, we would ask.
But does there have to be some consideration of prejudice to the government? That's sort of where the heart of my question is.
Right.
I understood Mr. Hawkins to say, look, the court just didn't assess prejudice, and that's really what delay is about.
From our perspective, we do not need to allege or demonstrate. And so in that respect, the trial court does not abuse its discretion by assessing a lengthy delay without prejudice being alleged by the government. We did allege some prejudice. We did point, I would say I have to admit in somewhat generic terms, that there was prejudice associated with witness memories. That's going to be true in every case, as I think in many cases, I think the defense pointed out. But it is a fact that the longer a defendant delays, the more prejudice to the government's case there's going to be. But the focus here for Judge Knowles, frankly, was that the defendant Mr. Hawkins had not done what he was, he hadn't done what he was supposed to do under the DSA. He didn't take advantage of the opportunity he had. And this was, to be frank, if a defendant is freely able to withdraw their plea after they fail to comply with a deferred sentencing agreement, given that the plea withdrawal was the carrot, that sort of defeats the purpose of the deferred sentencing agreement. So at the end of the day, Judge Knowles did not abuse her discretion here, and we would ask this court to affirm. And I see that my time is running somewhat short, but I'm happy to address any further questions the court has.
Can I just ask to clarify, going back a minute?
Sure.
I think now I understand your point to be with respect to the government's exclusive determination that this is a freestanding affirmative right that the government bargained for in the agreement that the government can invoke. And although it refers to a violation by the defendant of the agreement, it does not require the trial court to independently determine that the defendant breached a specific provision of the agreement, as long as the trial court determines that the government is invoking this affirmative right in good faith. Is that right?
I think that is exactly right, and certainly better than I put it. The one point that I would add to that is just that analogizing this to the substantial assistance context. Mr. Madsen said, well, this is not whether or not defendant is complying with the DSA is not as much within the ken of the government as whether a defendant is providing substantial assistance to the government. And whether or not that's true, and that's probably true, but whether or not that's true, that's not the important point. The important point is the government bargained for and obtained that through our agreement with the defendant. And so this court should enforce that. And I think it enforces it in the manner that you addressed there, Judge Schenker.
So then along those lines, you cited the case where we said that good faith, the circuit said good faith would be violated by an arbitrary or capricious decision under a term such as that. And so if the government decided in a hypothetical case without any violation of the breach that, or a violation of the agreement, that there's a violation of the agreement, you would agree that that would be arbitrary or capricious, right?
I'm not sure I necessarily agree because it sounds, I don't want to, but it sounds a little bit like what you're saying is if the government determined there was a violation, but there wasn't really a violation, that I think would entail the sort of independent inquiry, first order inquiry that we've that the defendant has in a sense bargained away. I think an understanding of arbitrary and capricious or bad faith, I think maybe the best articulation I've seen in the case law is in the Third Circuit's decision of in United States v. Isaac, which I believe is cited in the defendant's brief actually, but there it said, with good faith, the sole requirement is that the government's position be based on an honest evaluation of the assistance provided and not on considerations extraneous to that assistance. That's United States v. Isaac 141 F 3rd 477. That's from the Third Circuit. But you know, they're talking about substantial assistance. But here it's are we considering extraneous factors? Does this have to do with how with Mr. Hawkins' actual performance on the DSA? And you can certainly tell here, whatever else you could say about how the government approached this, how Judge Knowles approached this was 100% about his performance on the DSA. That was the focus here. And
I'm not disagreeing with you at all on that. I was saying that what I was trying to get at, which I didn't call, was there is an inquiry for a court to perform here, correct?
That's right. If there's an allegation, and this is where we're getting this from the substantial assistance cases to a large extent. If there's an allegation that the government has breached its implied covenant of good faith and fair dealing with respect to a DSA, there is an inquiry into whether the government has acted in bad faith, but that's a pretty high threshold, and it should not just be it's not you can't just get there by saying I disagree or there's a factual. It shouldn't be. You can't just get there with the types of allegations, frankly, in this case, where it's I just disagree with how the government's interpreting this.
And on a very brief final note, you mentioned the offer not to prosecute was really the carrot, but wouldn't you say the carrot was also dropping the other charges?
Yeah, I think that's an excellent point. I very much agree. That's not always going to be the case in a DSA. Sometimes there's only one charge in a DSA, but in this case, the government, the defendant immediately got the benefit of having two charges dismissed at the plea agreement. So that was an immediate incentive he received. Okay, thank you.
Thank you, counsel.
So the government has repeatedly stressed, that the government bargained for this provision. One, I don't think bargaining for the provision is dispositive. In many cases regarding illusory promises, it very well could be something that is bargained for. But two, regarding whether the extent to which
can you just the illusory description, can you just explain to me what you mean by illusory? Thank you.
So the provision providing that whether the defendant has violated any of the above conditions rests exclusively with the United States, leaves them a route of complete escape. That is, whatever the other terms of this contract say, they can at any time under that provision of the agreement say we are revoking the agreement for any reason we want. And an illusory promise is one that leaves a route of complete escape. And that is exactly what this provision does. That is, regardless of whatever the other terms say, under the United States reading, which I think they acknowledge.
Maybe I'm just picking a semantic bone with you, but it just seems like illusory seems to suggest that you're promising something that isn't real. Whereas this on its face seems to pretty bluntly say, we hold all the cards on telling you whether or not you have complied with your agreement, with this agreement. So I guess maybe it's really, as I said, just I'm quibbling about vocabulary, but illusory seems maybe not the right word.
So at least my understanding of illusory is that it vests sole discretion in the party purporting to promise the thing. Here, the United States, that is, they are saying, whatever else is going on in this agreement, they can revoke it for any reason they want.
But
at any
but
time.
that's not what it says. I mean, I agree with you. In contract law, an illusory contract is one that gives one party the right to back out of the contract for any reason. And that might be illusory, but that's not what this says. This says, first of all, the government has to determine that your client violated a condition of this agreement. And so, and you've seemed to have conceded that there has to be some good faith basis for that. So those two things seem to constrain the government to some extent. So now we're only talking about how one-sided the agreement is, short of crossing the line into illusory. And you can make an argument that these DSAs, as a general matter, tend to be very one-sided for the government. And that's an argument perhaps for policy people, but defendants enter into them all the time. And the other thing is, there's a lot of argument to be had about how much benefit defendants get out of them. I mean, your client got 2 charges dropped, 1 charge potentially dropped, ultimately no sentence if he complied with the agreement. So perhaps this provision swings a little bit towards the government, but there are other provisions or benefits of the agreement that swing toward your client. But at the end of the day, all of that is a quibble about how beneficial these agreements are to each side, as opposed to a disagreement about whether these are actually illusory contracts, meaning the government is not bound at all.
So again, Your Honor, and maybe this is a disagreement semantically, but that determination, if that determination is within the United States sole discretion to find that that the person has violated the agreement, that is no promise at all. There is without any check on that, right? That would be no promise at all. They could say, yes, we find the agreement has been violated under a straightforward reading of this that would allow them to revoke the agreement for any reason. The difference between the good faith cases originating in the substantial assistance context in this is that this provision applies to all terms of the agreement, right? Not something that is, again, that is just something about which the government would have peculiar knowledge, right? That is the extent to which they've cooperated, which obviously the government would be best equipped to assert. Here we have it going to every provision of the contract, right? They could say, whatever, you didn't call on this day, you didn't do this thing, right? With or without evidence. And under the United States position, which they're still continuing to assert here, I understand they say there is a implied covenant of good faith and fair dealing in every contract, but they're also still saying they have bargained for a provision that allows them to revoke for any reason. And so I think the court should take the United States at its word in order.
You argued that this provision should be struck. Is that right?
Yes, and
But then where would that leave you?
so that would
Right.
leave us with the trial court needing to itself evaluate, which it didn't do here.
So then there would be no power for the government to weigh in on whether or not your client had complied with the deferred sentencing agreement. You're just saying that the contract should be reformulated so that it was really up to the trial court?
No, I mean, certainly the government would be allowed to weigh in, just like Mr. Hawkins would be permitted to weigh in. But that determination would be with the trial court, yes.
So assuming we didn't think it was severable and we agreed with you, where does that leave you? Are we back now at the beginning and the government can bring the additional charges and we just go back to start and collect 200 and start going back around the board again?
So there's one implicit issue that I haven't thought through there that I would need to think about. That is whether there's some interest in finality that would be violated by reinstituting the original charges, but certainly not. Yes, definitely with regard to the offense at issue here, simple assault. Yes, certainly we would be back there. That is, and we can have a trial, we can enter a plea agreement.
But if the contract itself is void ab initio, then how is there an possible interest in finality for something you bargained for under it if it doesn't exist anymore?
Again, it's not an issue that is briefed. I understand Your Honor's point. It's not an issue that's briefed. I would be happy to, the court would like to submit a supplemental brief on that issue, but I'm just not prepared to answer that today. Thank you.
Thank you, counsel. We appreciate your arguments today. The case will be submitted.